what I wanted to share with you about your mortgage contract, besides the fact that you didn't read it, the truth in lending, 3-day right of rescission that you didn't take advantage of, only dealt with the bank assigning you the debt. It had nothing to do with the asset that you deposit to the title company that paid for the house and paid the seller. So you could have done a 3-day right of rescission and not accepted the debt, and the house still would have been yours. And most people don't realize that because they didn't understand that the debt and the asset are separate. So they feel if they did the 3-day right of rescission, they would have to give the house back, which is not true. The 3-day right of rescission is not accepting the debt that the bank is putting on you when they fail to do their part, which is this in exchange for this loan that they're going to hold your note, which they don't do. So now they're holding your asset and they haven't performed their end of the agreement. So you have a right to ask them to return your assets to you because they're making money off of your assets. It says in exchange for a loan. So if you were never given a loan, then it's a void contract, and they fail to perform their end. And so often we don't realize that we have a right to go in and correct mistakes. Attorneys, when they come to court, they make up stuff. The reason you know, because they weren't there. So what are they talking about? Why are they there? Why are they talking, period? They weren't at the closing table. They can't testify to anything, and you're going to let them talk? The only person that knows your business is you. Unless they can round up everybody that was at that closing table to come in and be a witness, nobody else can rebut anything you say. Now, the fact is we need to say stuff by affidavit because they cannot do an affidavit. Again, they have no personal first-hand knowledge, and they're not an eyewitness to the transaction. I created an affidavit of no loan given. You were there. Write the bank a letter and ask them for a copy of the front and back of the loan check that you were given. Ask them also to give you a copy for the note that you tendered. They can't do either because they weren't there. The only way they can give you a receipt for the note, they had to be present. Of course, they have the note, but they weren't the ones present when the note was tendered. Only the person that was present could give you the receipt. So if you ask them for a receipt and you ask for a front back copy of the loan check, now you have prima facie evidence by affidavit that there's no debt, there's no obligation on your part, and it's a void contract. Now, what the attorneys are doing for the bank is called service fraud. And it's a lot of very good information on YouTube about service fraud. They're bringing fraud on the court, and they're willfully exceeding the court into fraud, and you can make them pay for that. Because now they're violating your fundamental civilian due process, which is a priceless right. All your God-given rights are priceless. So, and rather than do a lien on their possessions, you do a writ of attachment, because whatever they possess is not equal to the violation of your priceless right of due process. And I encourage people to study equity, to learn how to use ecclesiastical law for your benefit, because attorneys are not allowed to talk in equity court on the private side. Just like the judge don't want to hear from you on the public, the chancellor will not hear from an attorney on the private side unless you neglect to strike whatever the attorney is trying to present. Because corporations cannot be heard in the private, only flesh and blood people. And that's very important for you to know where your rights are. If you are a people and not a public enemy operating under the Trading of the Enemy Act and the Emergency Bank Relief Act of 1933, the Trading of the Enemy Act was done in 1917. These are things you need to look up and read and redo your status to claim your private citizenship, because people are private. The all caps name which they created, that's the public enemy, and you're not that entity. So I want you to learn how to go back and correct your mistakes. It's never too late. Even if you've already lost the property, you can go back and redeem it. Your right of redemption is also priceless. You have a 3-day right of rescission, there's a 3-day right of redemption, and there's a 40-year right of redemption, which nobody ever talked about. To let you know, it doesn't matter when you lost your property. There's no statute of limitations on fraud, and that was fraud by concealment. They didn't disclose to you your right. They didn't disclose to you that it was a trust agreement. They didn't disclose to you that they were never going to give you the loan, that they were going to take your note, destroy it, bundle it together, turn it into a bond, and put it to trade on the international market. Well, that's money laundering. So that's unjust enrichment. You're entitled to get all your assets back, the note, the deed, all the payments plus interest, any money that was hypothecated. Those are called credit assets. You're entitled to, demand that back. And equity will see that, you'll get it back, because equity deals with good conscience and good reason. And equity always does what's fair, just, and right. Equity deals only with the truth. So you always have to go into equity with clean hands. And the bank or their attorney can't do that, because the attorney is a DBA. He's doing business as an esquire. So he represents the corporation. The bank officer represents the corporation. They cannot be heard from unless you sleep on your right and don't strike everything they say. Just move to strike, move to strike, move to strike. And the pen truly is mightier than the sword. If you write the right letter, you're going to get some action. Especially when you let the law firm know that I'm going to take everything you own. My Constitution man used to say, bank, business, and home. I'm taking it all for the unjust enrichment. What I'm trying to get you to see, when you want to go to the private side, you have to handwrite it.
Okay.
It cannot be typed. It cannot be typed. And you give it to the clerk of the court, not the judge's clerk, the court administrator, and you request an ex parte hearing with declaratory and injunctive relief.
Yes.
But it has to be handwritten. And the only way you can do that if your status is correct, that you're a private citizen. There's certain documents that you have to do. You have to have a revocation of the power of attorney that you signed, the limited power of attorney that you signed at closing. You have to have your oath of allegiance, and you have to have your copyright. Okay, well, you need an oath of allegiance to the United States and the unanimous declaration of independence in whatever state you're in. If any time someone is holding anything of yours, the insurance premiums are mortgages, car loans are mortgages, student loans are mortgages. You'd be surprised. Don't just think of a mortgage dealing with property or houses. Just like everything is a trust arrangement. Anytime someone is holding your property, well, other than the note, they have your application for the loan. That's an asset. The bank had a credit account set up for the exact amount of the note.
Mm-hmm.
So that's collateral. You also paid a down payment. You also paid for appraisals. You also paid closing costs, taxes, insurance, et cetera, et cetera, et cetera. That's also collateral. You have about 30 different trusts in a mortgage contract, and they're listed on the HUD-1 statement. All the different trust agreements and arrangements you've made that they did not disclose to you, that's what you were doing. Now, when you fill out an application, don't they keep the application? They're holding something that belongs to you. So now you can make it a deed absolute and turn it into a mortgage. And you can make them the subrogee and you become the subrogor. So anytime anyone is holding something that belongs to you, they are automatically the trustee. They cannot disclaim the trust because they have your property. And ask for a receipt. Start asking for a receipt for everything you sign. Because as long as your name is on it, it's your property. And if someone else is being custodian over your property, they are the trustee. And they cannot disclaim the trust, as I stated, as long as they're holding your property. Now, what you can do is turn the paper sideways and down the right margin. Put special, private, and priority. That keeps it from the public. You can go back and get your hospital records that your mother filled out when you were born. That's her property. Okay? My mother happens to be deceased, so I'm going to say it for me. So I can write my birth hospital. They have to go into the archives and return all the paperwork that she filled out to me because it was not my mother's intention to make my birth a public announcement. It was a private family matter. But the beautiful thing is, once you come into the knowledge of the truth, what the scriptures say, know the truth, and the truth is going to make you free. So let's go back and correct the mistakes. Don't leave them there as they are. Go back and correct them. Demand your property. You're not trying to intimidate them like they intimidate us. You just want to let them know you're holding my property without my knowledge and consent. So I want all rights, title, and interest returned, to me. It's like when they bundle the mortgages and they send them overseas. Well, no one told you that that's what they're going to do. So now they're making money overseas. You can get the IRS, believe it or not, the Department of Treasury, and the Bureau of Public Debt is also known as fiscal services. And I'm saying fiscal, FISCAL, fiscal services. Make them the fiduciary to go after that money that was sent out of the country that you weren't aware of, and have them go collect it for you, bring it back to you, form an LLC, and put it into the LLC, and they'll take care of you for the rest of your life. There's a website that you can go on there and put in your Social Security number, and they'll let you know every corporation that's making money off of your Social Security number. And I had like 574 corporations I knew nothing about. So this is what I did once I came into that knowledge. Like I said, you want to do revocation of power of attorney. You want to do a copyright. You definitely want to declare your status so there's no question, and do a notice of interest because that's your property. So the property's not abandoned. But before I had come into the knowledge of trust law like I am now, I was doing a termination of guardianship because each presidential administration administers your trust. And I'm sure you've heard of the Sister KB Act of 1666. So every president from the time I was born, so I go back to my birth year, and the president then until the present administration have administered my trust. Now I need a termination of guardianship because I'm of age. I'm of the age of the majority. I'm not dead, that I'm alive. And when the true beneficiary shows up, all administration ceases and have them do a full accounting. And all the money that was made off of my birth certificate and my Social Security number, they have to give it back to me. So it's not cash money. It's private credit. So you can't put it like in a public bank account. That's why you want to form an LLC, a private corporation, and let the judge assign you a trustee. And they will take care of all your needs, your life maintenance, as long as you live. They will take care of all your needs. They'll buy your houses, whatever you need. You just submit a request, and it's done. But it's not cash money. It's not Federal Reserve notes. It's whatever type of conversion or credit money that they use. So that's how it operates on the private side. They've been spending mine however they want ever since 1949. So, I'll be 68 this year. They've had access to my monies and interest for quite a number of years. The reason they don't pay the taxes is because they have your mother sign her maiden name as though she's not married. So that causes you to be born without a father. That's why they always have the mother sign her maiden name, not her married name. So now the state can take control of the illegitimate child. See?
Yep.
That makes the child illegitimate. You can discharge any debt. They provided a way for you to do it. And it's out there on the internet, in your face. And people don't even know it. I'm not telling you to take the road that I took because it was very painful. It was very hurtful. Your own family members turn on you and start talking about you and think you operating 2 courts short of the 5 courts you need. You know what I'm saying? You need to restate that because they didn't loan you money. That's why you're asking by affidavit for a front and back copy of the loan check, which they can't provide you because they never gave you one. There's only one entity in the United States licensed to make money, and that is who?
Corporations?
It's the Federal Reserve Bank. Banks can't loan money. They don't have money. They would have to get it from the Federal Reserve. So if you did owe money, you would owe money to the creator of the money, which is the Federal Reserve Bank. You wouldn't owe it to a subsidiary bank because the property would be that of the Federal Reserve, not of the bank. The bank would be a fiduciary. It's like when you open up a bank account, they're your fiduciary. Well, no one taught us how to make that account private. Again, they're holding your assets. That signature card, that's an asset of yours. They're holding your property, and you didn't write on it that it should have been private. No one told us that we could. No one told us that we had that option. So now when someone wants to get into your account, say like our friendly I, R, and the S, if it's a private account, they can't access it. But if you're public, you don't know how to declare your status and make yourself a private people instead of being a public enemy person. They are making money on your trust account. They're managing your trust. Say, for instance, your birth certificate bond is a savings certificate bond that you were supposed to collect on when you got 18, but nobody ever told you. So now the interest on that bond is constantly accruing because no one came forward and said, I'm alive, I'm not dead, I want a full accounting of the investment that you did with that bond. And I want all the rights, title, and interest returned to me. That's the way I want you to think about it. See, everybody thinks that the federal government is your enemy when it's not the feds that's your enemy. Guess who your enemy is? It's the state. Who controls the court? The state. Who does the judge work for? The state. Who does the DA work for? The political subdivision of the state, because the DA works for the county. Just FYI. And the state gets what? Federal funding. So the state is being funded from your trust money, from that birth certificate bond, from that Social Security trust bond. So who's railroading you in court? Who runs the state? The Bar Association. Hello? No, that's how trusts operate. You're the beneficiary. And if you know anything about trust law, the beneficiary gives orders to the trustee. And the beneficiary tells the trustee, I want this car. I want this house. Make it happen. Anything for your life's enjoyment and maintenance, that's how trusts operate. There's a limited power of attorney. If you've ever been to a closing, you know they rush you through signing and initialing the closing docs because they don't want you to read them. Well, you have a right to get a lawyer's package so you could take it and read it for yourself, plus you can have an attorney read it. But now remember, they're in cahoots with each other, collaboration. They're conspiring against you. And as far as the attorney knows, everything is correct. But when you never get the loan check, then you should ask the attorney. Now what happens? They never gave me the loan check. It's a void contract. If you and I make you an offer and you accept it and the consideration is for me to do something and I don't do it, it's a void contract. It's not enforceable. When you fill out an application for a loan and you are approved, the next thing the bank does is cut the check to you. You would have to endorse the check for them to do that. They never did that. Your promissory note was monetized. That's what paid the title company and the seller. And they're going about their business. Now here comes the bank asking you, are you going to accept the debt to repay this loan that I never gave you? And because you don't do the 3-day right of rescission, you accepted a debt that you don't owe. My revocation of power of attorney said I rescind, I revoke. You know, a rescission is when you rescind something. The revocation is when you revoke something. So I do a signature rescission, revocation of all initials, signatures, and marks. Even if my pen accidentally put an ink spot on the paper, I'm revoking all of that.
Okay.
So you want to make it crystal clear that they understand your intent and purpose. That's how trusts are formed. As long as they know what the truster's intent and the purpose of the trust is, you don't need a trust indenture to have a trust. You need intent and purpose of the trustor. And what's the intent and purpose of the revocation is to remove your signature nunc pro tunc. That means all the way back to conception, the 9 months before your earth arrival date. That's the type of revocation I do.
Right.
Everything that you sign is an asset of yours.
Right.
And when you fill out the application and you're approved, it creates a credit asset, which is a bank account that the average person is not cognizant of. They don't even know it exists.
Right.
But they know about the note.
So
there was so much money, and the fact that they transfer you from the borrower to a lessor or a tenant.
Mhm.
Those are called clogging provisions. And that's a violation of your due process, and it's a violation of your right of redemption. So whatever collateral that they may have, whatever liability insurance they may have, those rights supersede any monetary amount. So you can just wipe them out. Make sure you get people's names because they have bonds, because you can claim that case number. I'm gonna share with you how to claim the case, how to claim your docket number. Remember, private things have to remain private. Once you put a notice is public. That's why I say trust law is so powerful. You really need to investigate. You have to terminate your guardianship with the alien custodian. You are an agent for the all caps name. Now, the reason being, let me explain it to you this way. On your application for a name, the last name was always known. Then your gender. Then your first and middle name, if you have a middle name. But you were, for instance, your last name is Johnson. You were Johnson, Boyd, and then we're going to give you a name of Robert James. How about that? So you're Johnson, Boyd, Robert James. Now, they took that name and turned it around and capitalized it. But on the application, your last name always came first. Always. So because you write your name the way they taught you to write it instead of the way you were named, you need to correct that. Sign the last name first, comma, first, hyphen, middle, or either last name, comma, first, middle initial, but never first, middle, last. Because you're the agent for the all caps name. Stop forging that signature. I know how to use this same bond to discharge a mortgage, discharge credit card, car note, student loan, hospital bill, IRS debt. That's a programming that they have. It's a psychological, reverse psychology, whatever you want to call it. They're teaching you to do what they're telling you not to do. The people's taxes is not what's running our government, paying our Congress and senators billion-dollar salaries. That's coming from our trust account that nobody's made a claim to. Again, the Cesar KB Trust Act of 1666 says that you're dead and lost at sea. And until you come back and say, I'm the beneficiary, they're going to continue to administer your estate or your trust from president to president to president. That's how it's been done all the time. Ever since they created, this is fraud at its finest. This is fraud at its finest. It's a magnificent piece of work. And you have to appreciate it that, you really have to study to get uninvolved and unentangled in their web of deceit, lies, and cover-ups. Attorneys are not even lawfully able to operate in a courtroom. There's no congressional law, no legislative authority that allows an attorney to even walk into a courtroom and operate as an attorney. People can do stuff how? By affidavit. And the unrebutted affidavit stands as truth in commerce if it hasn't been rebutted in 30 days. And that's a fact, and it's called a material fact. And yes, you can, because it takes another man to rebut a man's affidavit. Anything you do, as long as you do it by affidavit, it takes another flesh and blood person, people. It takes another flesh and blood people to rebut that. A corporation cannot. They took away our privacy without our knowledge and consent. Now somebody has picked up the Trading with the Enemy Act and the Emergency Bank Relief Act of 1933 and realized that it's not applicable to us. So again, you have to use the eraser on a pencil and go back and correct the mistake. Don't assume I'm a public citizen, which I'm not. You could fill out a driver's license application and put on there that it's private. You'd be surprised what that'll get for you. Start putting private down the right margin of your document. That is special, private, and priority. Start restricting your signature by colon. If you're going to sign first name, then last name, put by. And then put agent after that because you're the agent for that name.
I was just wondering, how do you utilize an unrebutted affidavit?
You file it on a UCC-1 and use it as an exhibit. Okay, but you have to have an affidavit. You know a QWR, which is a qualified written request?
Right.
Okay. When they don't answer it, you have to do an affidavit of noncompliance to clearly written and established federal law. If the affidavit hasn't been rebutted, you have to have a document that this is an unrebutted affidavit, and you have to state the dates and times to show that it is an unrebutted affidavit by affidavit. That's what I'm saying.
I got you.
So where's the corroborating document? Right, and the unrebutted affidavit helps make a prima facie case when you're on the public side. The better side for us to be on is the private side. So when you learn better, you do better. And when I started understanding trust and that we're private people and we're too busy trying to straddle the fence, you know, we're trying to be a private people and a public citizen, and you can't commingle.
Right.
That's when you go to jail, when you commingle.
Oh.
Well, if you go into court for any reason and you tell them that I'm a flesh and blood person and my rights cannot be seen by this court, my rights can only be seen in the private because they're trespassing on a private trust, you claim that court case with special deposit and return it as trust res, you own them. You own everything.
Okay.
But you're not the name, you're the agent for the name. And only use your first name to keep it simple so you won't get confused. When they say your full name, that's the all caps name. When you're being an agent, just use your first name so you'll remember the different positions. You're not accustomed to signing your last name first. So just use the first name, no surname. And you need the declaratory and injunctive release to stop the process.
Oh.
And you also need to make the attorney, because he's doing an invasion of privacy and identity theft using your name without your written consent, you should make them the trustee. If you defaulted them and you did it properly, then you take it to the clerk of the court and get them to sign off on it. The clerk of the court signs the default judgment, providing your mailing process is correct. If you did the administrative process, you gave them a notice of fault, an opportunity to cure before the default, the clerk of the court will sign off on it. You need to establish a rapport with the people you're going to be doing business with. Ask questions. Tell them you're a student. At the time, I was a student. My whole conversation is about equity and how to become private and do things on the private side. And the reason you can do it is because you're asking for it to be sealed and ex parte, which means that it excludes the public and the press, which is why you're not allowed to talk about it, because you're asking for it to be sealed and ex parte, which excludes the press and the public. If you get a copy of your mother's application for your name, you'll see that the last name was first. Your gender was second, then your first and middle name. That's your evidence. They turned the name around and put your first name, middle name, and last name. That is not how you were named. You always had your surname before they knew if you were a boy or girl. You had that last name. Because a business, remember now, all corporations are considered legal persons that can sue and be sued. Again, you are not the name. You are a flesh and blood, God-created, spirit-speaking man. There's no way that you could be a corporation because you're flesh and blood. Corporations don't feel. You feel. You have emotion. Corporations don't have emotion. Corporations do not suffer loss. Like if someone that we know and love happens to transcend. The fruit of the Spirit, it doesn't matter if you believe in Scripture or not, but the fruit of the Spirit, love, joy, peace, corporations cannot experience that. And it's very important that you know you are not an individual. You are not a person. You are a flesh and blood, spirit-speaking man, God created. That keeps you in the private. My copyright that I referenced earlier, it's a biometric copyright. And I copyright all the things that God put inside of us. That's our RNA, our DNA, all our bodily fluids, the epithelial cells. I put a copyright on everything. And all of that is inside the appellation or the name. And your name is how your mother chose for you to be addressed. And she addressed you by first name only. I doubt very seriously she called you your whole name when she was calling you. She always called you how? First name only. That denotes the living being. You're not an entity. Well, you're incorrect because the all caps name represents a decedent. You need to look up the dead man's law for your state. They have a dead man's law. That's why they put all caps names on tombstones in the graveyard to represent the decedent. The decedent is a live person. The all caps name represents the flesh and blood human being if you don't know how to separate yourself. The all capital name represents a decedent who's walking around, living and breathing. The decedent doesn't necessarily mean after transition. You're considered a dead man. Again, the Cestacate Act of 1666, until you come forward and terminate the guardianship of the alien custodian, you're considered dead and lost at sea. But once you come forward and terminate the guardianship and let them know you are alive, the administration of your trust in your estate ceases at such time. Okay, the decedent is not necessarily a dead person that's buried and dead. They consider the all caps name representative of a decedent. That's what the dead man laws are. The box what you put the money in when you have a payment due and they want you to write the amount that you're sending in, it's called a tombstone. And if you haven't taken accounting, you would know that. But everything that they design, everything that they orchestrate is for a decedent that's alive, but they don't know who they are. And they're taking full advantage of that while they constantly perpetrate fraud on the living and breathing man and woman. Well, not only does the Cestacate Act talk about the property that they got in England, it also declared every man and woman on earth is dead. That's how that happened. That's how we all became living decedents. You've heard of merchant law. As long as you're handling Federal Reserve notes, they consider you to be knowledgeable in banking, which you're not. So you ask, how are you supposed to know these laws? Because any civilized society is governed by laws. You have to know the rules of the community. You don't have to know their civil law, but God's law. That's what makes you, for lack of a better word, that's what makes you sovereign. You go into court and let them know there's a conflict between law and equity. Those are the exact words you would use. There's a conflict here between law and equity. And anytime there's a conflict between law and equity, equity prevails. They have to go to the private side. You're not allowed to commingle the public and the private. I don't know of how many of you are familiar with James McBride. He wrote an instrument for $7 trillion that Treasury negotiated for him, and they notified him that they negotiated the instrument. They asked him, where do you want us to put the money? He gave them the instructions, what account he wanted that money put in. They deposited the money in that account, called him, said the money's in the account, you got 24 hours to move it, or we're going to take it. Not only did they take the money, he's in jail. Why? Commingling. You can't bring money from the private and put it in a public bank account. The reason why I need to make this clear is because you cannot use law, statutes, and codes in equity. You can only use the 20 maxims. You cannot use any type of law in equity. That's commingling. You can't use equity in public court. That's commingling. That's why you have to say there's a conflict between law and equity. Equity was here, before this country was formed in 1776. Equity was on the planet. I don't know if you ever heard my first example of what equity is from the scriptures. And that was, the example I used was the woman who was caught in the very act of adultery. That's how it's worded. I find that so interesting. How do you catch somebody in the very act unless you're a peeping Tom? I'm just asking. You know what I'm saying. So all these men bring this woman before Jesus and said, she's committing adultery, and what does the law say? And he kneels down and starts writing in the dirt. And he says, he who is without sin, let him cast the first stone. So everybody left, and it was just Jesus and the woman standing there. And he looked up and he said, woman, where art thou accusers? And they were all gone. Well, the equity of the matter is the injured party, which would have been her husband, is the only one who could bring the claim. You can't bring a private claim to somebody else at court without the power of attorney, conservatorship, or something like that. That's equity. There has to be a real flesh and blood injured party. Equity deals with people, not corporations. No state can write a law to supersede federal law. I run into people who say, well, I can't carry a gun because I'm an ex-offender. What law says that? Because it's not federal law. Federal law says the right of the people to keep and bear arms shall not be infringed. There is no subparagraph A, B, C, or D, and there are no stipulations to that. Anybody can carry a gun. The federal Constitution says so. The state says otherwise. I just told you the state cannot write a law to supersede the Constitution. Whenever there's a conflict, federal law always prevails. Whenever there's a conflict between law and equity, equity always prevails. The Constitution was meant to be an equitable trust document. Why do they always say you're breaching the public trust? Everything is trust law. I have my private name, which I did a lawful name change in 2006, and I have my birth name, which I operate in commerce with. Everything in commerce is done how? By notice. So if you're going to be a private citizen, you need to put them on notice. It's called an oath of allegiance, because private people make oaths. They do not swear. Your word is bond. So if you're giving somebody your bond, you're giving them your word. I'm going to share one thing, and this is really none of you guys' business, but I have credit cards. I don't have a bank account. I have credit cards in the store name that I use to travel with because I need to book my flight. But, I know how to handle that.